So I hope you understood the graph of negative rights. You have to draw, not draw that graph, but that is the flow how you are supposed to answer the question. The right to use whatever you have, it is against the entire world. It is against the entire world. There is nobody else in the world that is going to enjoy the asset or derive benefits from the asset without your consent or your permission. That is your negative right. Okay? That is your negative right. That is the concept of what is negative rights. Yes, write your attendance in the chat box. Let's move on. Now let's understand what is intellectual property rights, whether it is individual right, societal rights, or community rights. Okay. Now, first, let's understand what is community rights. If you are working in any organization, you might have a trade union or a employee groups, group one, group two, group three, and all. Whenever a proposal is there discussing your salary or your benefits and all, or your welfare expenses and all, there may be agreements or disagreements with the management. So whether you are supposed to receive any incentive, what are your working hours, what will be your working conditions and all, you always have a right to discuss it with the management. It is not the case that always whatever the management says you have to follow it. So this right that you have to discuss with the management, we can call it as a community right. Okay, so basically trade union or any employee groups, it is a community. So the rights that these communities have to discuss with the management or with the government or with anybody for a specific objective, we will call them as community rights. Now let's see what is societal rights. Society rights or societal rights. If you are living in a society or in a country, what you are expecting from the government, you are expecting from the government that there is adequate infrastructure, roads, then a government is providing you education, not the entire advanced level or higher level education, but the basic education. Then also the government is providing you with electricity, water, and all. So that is your right, and you must claim it from the government. So it is your societal rights. It is your society rights. Now this intellectual property right, it is not a societal right. It is not a community right. It is your individual right. Whatever you want to do with the property, you can do with it because it is an individual right. Okay, so question might become in a twisted manner that what is IPR, whether it is individual right or societal right or community rights. And they may even ask you what is societal right, what is community right, and they might also ask you true or false and also. Now you have understood it, I hope. Let's move on. Now let's see what is patents and copyrights. What is the difference and how to understand what. Whenever you are inventing something in the field of science, architecture, any kind of information technology, or any engineering, you are supposed to get a patent. Okay? You will not get a copyright, you will get a patent. If you want, you can remember this patent as seat. You can remember this as seat, that it might, you might give the examples. Then copyrights. When to use the copyrights? Whenever you are writing any book or all, for example, literature. Then if you are composing something, music and all. Then if you are a photographer, then any arts, other like dance, drama and all. And then if you are a painter, you're not the wall painting and all, there's different kind. So You can remember these copyrights example as lamp. Okay. What? Lamp. If P is 2 times, so I will just write lamp 2, P2, lamp. Okay. So patents, you have to remember seed and lamp 2 for copyrights. So if they ask you that whether you will get a copyright if you have made a uh, invention in science or some advancement in science, it is a incorrect statement. You will get a patent if you are making any advancement in science. Okay. So first understand which intellectual property right you are falling under, whether you have to get a patent or you have to get a copyright. How you will understand that? Remember this list of inventions. Okay. Let's move on. Now let's discuss in detail what is a copyright. Now I know that how to get a copyright, when to get a copyright and all. They have not discussed it in detail. These are just provisions that they have given in the law. If you want to know what is the practical if you want a practical understanding of everything, please do it on your own. We will only be covering what is covered in the law so that you understand the law and you can take the correct course of action in the meantime. But if you want to understand it practically, you have to do it on your own. Okay. So I have cleared it in the beginning itself that we are only going to understand what is the law in relation to intellectual property rights. Now, P. Goldstein has defined or given us some explanation for what is a copyright. As per him, what you are trying to control when you get an intellectual property right, you are trying to control creation and use. So, if you have prepared a software, if someone else is also preparing a software which is a duplicate of it or in the same manner, you will have a right against that person. Okay, so you can also uh, get a copyright that nobody else is preparing the same thing that you have prepared. Okay? Or using your software to do something. If you want to use that software for doing something, you have to take the permission of the person who has made that software, and then only you can use it. Okay, we are not talking about pirated software. We are talking about the softwares which are originally nature. So what we are trying to control, we are trying to control the creation and use of these properties. Now, what are the provisions? How to make sure that we are complying with all the services and all. So you have to refer which act? You have to refer Copyright Act 1957. Okay, this is the law that you have to refer to. Then it says that you have exclusive monopoly. What does it say? It says that you have exclusive monopoly over the property. You are the exclusive owner. If someone else wants to use your asset, he has to take a permission or your consent for use of that property. Now, if you get a copyright, you can use that copyright for 60 years. It is a very long right. You can maintain it for 60 years. Then what happens if you die after 60 years? Okay, well, you have got a you have sang a song, you have made some music, you have made some movie and all. You are receiving money for the copyright and all. Now you have died. What to do now? So now the whatever the money is in relation to the copyright, your legal heirs will receive that money now. Or whatever the exclusive monopoly is there or your rights are there to use the assets, it will be passed on to your legal heirs. So make sure that you are mentioning who the legal heir is in your nomination clause of whatever document is there. Then this copyright you have to write in electronic form. Obviously, you have to submit it to the concerned government department that I want to get a copyright of this. You have to give it in writing in electronic form and then you have to submit that application. Okay. So remember we explained P. Goldstein for copyrights. Remember, copyright means gold, steam, so in that manner. Then 1957 and 60 years. And here we have a special case of legal heirs. What to do if you die after 60 years or within 60 years. So let's move on. Now let's see what are trademarks. So we can say that it is a symbol. Whenever a person is talking about something, he will try to create one representation or a symbol so that people will focus on that symbol instead of any individual or the name of the company and all. They will buy that product because of that symbol. For example, Levi's, the shirt or the trousers and all, whatever the clothing is, if it has only the name written on it, Levi's, you can understand the difference in price with the local garments and that quality of clothing. So why we are giving this symbol? To tell them, to tell the customer that it is something distinguished, it is not of the same quality or the same procedure and all. So how do you distinguish your products from other products is by giving it a symbol or a trademark. You know what is branding and all. Now, whatever the laws are there, it will be covered as per Trade and Merchandise Marks Act 1958. Now this has this is in old act. If you want to see the updated version of this, you can refer to Trademarks Act 1999. Once you get a once you register for a trademark, the validity is for 7 days. Okay, so if you only apply for a trademark, it is valid for 7 days. And after 7 days, if the registration is done, you can have it for the lifetime. Okay. Now, does anybody know what mark you have when you register your product? Or whatever your product is, it will have this R mark on your product. What does it say? It says that it is a registered trademark. If you want this trademark, then you have to consult with the owner. If you want to use this trademark, if you use it for your own products without the permission or the consent of the owner can take legal action against you. Okay. So that is the point of legal action. For copyright also, we have a mark like this. Just understand when we will use a trademark and when we will use a copyright symbol. We don't have a patent like this. Okay. We don't have something like this. Now, if I am writing something on the board which is not yet written in any literature, or I am coming up with a formula that was not founded yet, which tell me whether I will get the trademark, whether I will get a patent or I will get a copyright. Okay, this is my question. If I have come up with a formula in a ratio analysis chapter of your management accounting that was not yet found or derived by anybody else, then will I get a copyright for it or a trademark for it or a patent for it? That is my question. Yes, tell me what I will write on my formula, whether I will write C, P or R. Okay, so the answer is I will get a copyright for it. Okay, I will not get a patent for it or a trademark for it. I will get a copyright for it. Why I will get a copyright for it? Let's go back a minute. Okay, whatever I am doing, it comes under literature. That is the reason I will give it I will take it under copyright. Okay. If if I am writing something as a teacher in a book and all, it will all be covered under literature. If I am preparing a bomb and all, okay, and that bomb has a more explosive capacity than any other bomb, then I will get a patent for it. Okay, but if the same inventor is writing something in a book, then he will get a copyright. He will not get a patent. Okay, so you can. I hope that you have understood the difference between patent and copyright. Okay, so if I am coming up with a new formula that was not derived till now or till date, I will give a. I will get a copyright for it. Okay, my book will have a copyright. It will not have a trademark or a patent. Okay, let's take a break of 5 minutes. Then we will join back again. Hello. Okay.